Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Somebody asked me, what's the wildest thing you've seen happen in a trial or at the courthouse? And that's kind of a tough question because if it's happening in a trial, it's probably a trial I'm running, which means that it's going to be covered by confidentiality. Legal ethics say I can't talk about it. That's the client's business. Even if it happened in open court, it's not for me to make a video about it. If it's happening at the courthouse and it's not one of my files, I'm probably not present for it. So there have been some wild things that have happened at the courthouse that I just wasn't there for. I narrowly avoided being present for a shooting that happened at a courthouse, but I left before that went down. I didn't see it. That said, some wild stuff does happen in trials, and I can talk about stuff that happened to other people's clients if it's been reported in a public decision or that kind of thing. And if we want to look at where stuff really gets wild, like really crazy, criminal law isn't the place. Family law is where that action is. And that's because when people are involved in family disputes, sometimes they get a little crazy. Sometimes they're not thinking straight. Sometimes they do stuff that maybe they shouldn't. So let's have a look at one of these cases and just talk about what went down in this case and just how wild that would have been for everybody involved, how crazy it would have been to be involved. I poured myself a glass for this one. You might want to as well. I'm also going to note that I have taken a bit of an unusual step, notwithstanding the fact that this is a publicly reported decision. I've gone through and I've redacted a fair bit. I've redacted the names of the people involved, and that's because this is a family law dispute that involves a child. So the publicly reported decision indicates the child's name and their parents' name and a bunch of other details, and I don't really like that. I wish that those family decisions would just, preserve the privacy of the people involved and not share all of this. I don't think that many people who know the child are likely to be looking this up on, on Canly or the like, but that child certainly doesn't need to have a video out there, with her name in it, where I'm talking about the bad behavior of her parents. So you could look up the names if you really wanted to. That's all public information. I'm not including them in this video. That's my call. And, it's not a legal ethics thing. That's just how I feel about this. So that might make it a little confusing. I'll try to keep it, I'll try to explain who's who, but they're all the names have been blacked out in the document here. All right, let's jump in, and we're going to jump in sort of in the middle to the interesting bit here. So preliminary comments on credibility. So there's several witnesses who have testified in this trial, and the judge is going to comment on, do I think these are honest witnesses? Do I think they're reliable witnesses? Can I trust that the things that they say in court are true? Either because they're, either because the witness might be deceptive, or because the witness might be biased, or because the witness might be in some way incapable of providing an accurate account. They saw something, but their vision is blurry, that kind of thing. So let's have a look here. Credibility usually means more of the honesty aspects, but it includes a whole bunch of different elements to it. So there were three main witnesses in this trial: the mother, the father, and Miss Blank, the paternal grandmother. So the grandmother there. Although both parties called a small number of corroborating witnesses, the vast majority of the trial was spent on the testimony of these three main witnesses. I find that neither one of these witnesses at the end of the day had much credibility, so nobody is trustworthy. Yeah. So the father we're going to start with, and this is going to go in order of sort of, well, let's just say that the ending on this one is kind of a bit of a bang, so stay tuned. But we're going to start with the dad here. For reasons that remain unknown to me, the father during his testimony had real difficulty answering simple questions or remembering events that ought to have been easy to recall. This is one of those signs of dishonesty when people are sort of, oh, well, I can't remember. How can you not remember that? If you have these convenient gaps in memory, that kind of suggests that somebody's testimony may not be good. For instance, his cross-examination revealed that he had not been truthful about his criminal record, having denied that he had one in his examination in chief, when in fact the evidence confirmed that he had a criminal record, uttering death threats to the mother's boyfriend, blank. The father also denied having signed the agreement, which led to the 2015 parenting order being approved by the Quebec court when it was clear that he signed the agreement. He later changed his answer to say that he could not recall. I mean, how do you forget these things? The father also made several statements, sometimes very bold assertions, which were later clearly refuted by other compelling evidence, including from his own witnesses. Oh, his lawyer was probably having a rough day, but that's family law. There's a reason why I don't venture into it. Examples of this included, but were not limited to, the following. The father claimed, in no uncertain terms, that during their relationship, the mother was a drug addict and an alcoholic. That's a hell of a set of allegations to make. You're going to want to have some evidence for that, right? Not only were those claims not proven at trial, no evidence provided, the uncontested evidence before me is that the father could not explain why, despite his strong assertions in that regard, he chose to leave his very young child in the primary, if not sole, care of this alcoholic and drug-addicted mother when the parties separated in 2013, when the 2015 parenting order was made, on consent, or when he filed his original application in this litigation. So this is one of those things where that allegation, you can think of it as a loaded gun that he's, firing here. But you kind of have to think, where exactly is this gun pointed? Because when he says, hey, she's an alcoholic and she's a drug addict, what you see is the court says, well, if she's such a bad person, how come you were okay leaving your kid with her? That's an example of him pulling the trigger on a gun that he just didn't really think about where it was pointed, because that was also aimed at his own head. Yeah, that's a rough moment. The father denied that a social worker had completed a comprehensive parenting assessment in the context of the legal proceedings which led to the parties consenting to the 2015 parenting order, and apparently recommended that the daughter be under the mother's exclusive care. I was never provided with this assessment. When faced with evidence clearly confirming that one had been completed, the father said that he could not remember. Why would he want to forget about an assessment that says that the daughter should be under the mother's care? That's a toughie. All right, let's keep going. The father claimed that he was completely denied access to the daughter after the parties' separation, a statement that his mother later contradicted. When your own mom is contradicting your sworn testimony at trial, that's a moment for a drink. All right, keeping on. The father claimed that the mother had failed to notify him of her intention to change the daughter's school in Ottawa, and that she refused to tell him where the daughter was registered in school. This later proved to be untrue, as the father received a letter from the daughter's school that year, and he and members of his family had attended the daughter's Christmas play at her school that very same year. His mother, in her testimony, confirmed that the paternal family was aware of the many changes of schools for the daughter, something they felt was not in the daughter's best interests. So they don't exactly have their stories straight here. He's saying, I don't know where she's going to school, but they actually physically showed up there. Yeah, that's rough for Dad. The father's story about whether he knew who the daughter's doctor was kept changing. At times he stated that he never knew who her family doctor was. Then he acknowledged that it was his own family doctor. This isn't even the worst thing to happen in this trial. This is just the warm-up, guys. So there were also a number of statements made by the father and positions taken by him which significantly and adversely affected his credibility and made me question his parenting skills and ability to put his daughter's well-being at the forefront. So it gets worse. For instance, the father, during his testimony, made it clear that in his view, it was not his responsibility to make efforts to obtain information about the daughter. It was the mother's sole responsibility to chase him down and provide him with that information, whether he asked for it or not. As an example, although he knew where the daughter went to school, he acknowledged that he had made no efforts whatsoever to contact her teachers or seek out information about the daughter's progress in school. Can you imagine that as a parent, just being completely disinterested in how your kid's doing at school? That's not exactly a strong point in a family dispute over, custody. In his view, the mother had an obligation and the responsibility to provide him with everything he needed to know about the daughter's education and her failure to do so ought to reflect poorly on her parenting skills. You know what? Maybe she should have been providing him with information, but certainly if she's not, you'd expect him to ask. You'd expect him to start getting upset about this, to start, maybe bringing a court application to say, hey, I need this information. Maybe going to the school and trying to get that information. There's all sorts of things that you should be doing in this. And if he's not doing any of them, that doesn't help him at all. The father stated that if the daughter was placed in his care, he would obtain a comprehensive assessment to determine the causes of her struggles in school. He claimed that he knew nothing about the steps taken by the mother to have a psychoeducational assessment completed for the daughter. However, the evidence clearly confirmed that the mother sought the father's support and financial assistance to obtain such an assessment on a number of occasions, and that he either ignored her requests or answered that he would not pay for this. I mean, how are you going to go and say, hey, I'm going to go and get this assessment done when you've been specifically saying, I'm not going to pay for this. This is terrible. There's moments when, as a lawyer, you're just watching your witness just flounder and get decimated on the stand. It's never a lot of fun, but at the same time, I mean, that's on the witness. They've made their choices. The father stated that if the daughter was placed in his care, he would arrange for counseling for her and would be very supportive of same. The evidence before me makes it crystal clear that when invited to attend counseling with the daughter, at the mother's request, the father not only refused to take any part in it, he made it clear that he would not pay for any of it. In the father's view, the mother was clearly to blame for having been assaulted by her former partner, whose name I've blacked out, but it's just she had another guy apparently at some point in this, and she was assaulted by him, and the dad says she's to blame for that. Do you think the court's ever going to agree with that? Nope. That's a terrible thing to say in court. Terrible thing to say outside of court, but yeah. The father steadfastly refused to adjust his basic child support to what the child support guidelines required, or to pay for any of the daughter's special and extraordinary expenses since 2015. He stated that if the court ordered him to pay for those, then he would. Not before. When you're trying to set yourself up as, hey, I am the caring father, this girl should be in my custody, not the mother's, because I am such a good dad, you kind of want to be there for the daughter. You kind of want to put the money out. Because if you're spending the money only on yourself, might not sell things to the court. So based on all of the above, I found it very difficult to give any weight to the father's evidence as a whole. Not surprising. All right, on to the grandmother. So this is the father's mother here. It was not difficult for me to conclude, as was alleged by the mother, that this litigation was driven to a large extent by the paternal grandmother and not by the father. So she is the engine of this litigation. She's the reason why he's seeking custody here. I did not find that the grandmother was credible as a witness for many reasons. First of all, her anger and hatred towards the mother were so acute and so obvious, it completely tainted anything she had to say about her. For instance, she referred to the mother as inhuman, stated that she had destroyed her family, put her family through hell, brainwashed the daughter completely. Conflict related to the mother's alleged failure to pay rent to the grandmother while she lived in a property owned by her after the parties' separation, and the mother's alleged wrongful removal of household items belonging to the grandmother led to litigation between them before the Quebec's Tribunal Administratif du Logement. So that sounds like the landlord-tenancy board kind of thing. Clearly, the relationship between the mother and the grandmother has been toxic and highly conflictual. That happens, but it does harm your value as a witness if you just really clearly hate somebody. Undoubtedly due to their very damaged relationship, the grandmother was incapable of showing any objectivity at all while testifying about the mother. Her testimony was full of exaggerations and overstatements that were simply not supported by the evidence. She completely downplayed her son's wrongdoings, even those that were clear on the evidence, such as his non-payment of proper child support for the daughter, while exaggerating and overstating all of the mother's misgivings, showing a complete inability to recognize any of her positive attributes as a parent. So let's talk about this. I mean, when the court is looking at a witness, it's not necessarily that the strongest witness is one who takes the strongest position in, on your side. It's somebody who can offer the court useful information that supports principles you want the court to adopt, but also doesn't seem like a crazy person or doesn't seem like somebody who has an axe to grind. Sometimes the best witness is somebody who says, listen, both of these people are terrible, but here are the ways in which they're terrible, so long as those different details end up helping you out, in the end. So where you have somebody who might be completely on your side in terms of what they're saying, it may not necessarily mean that they're going to be a useful witness to you. Here, the grandmother was not, and that's, again, because she's just so much on one side here. She's not sort of offering an unbiased and objective and fair assessment of things to the court. In relation to the first litigation before the Quebec court in 2015, she could not remember if a parenting assessment had been completed by a social worker, who, according to the mother, had visited the father and the grandmother on a number of occasions in the context of that process. When cross-examined on her role as the driving force behind the Quebec litigation, which had been unnecessarily prolonged as a result of the grandmother's refusal to sign the agreement as the father's legal guardian, the grandmother's vague answers and flat denials ended up corroborating the mother's evidence in that regard. I find as a fact that back in 2015, the grandmother refused to approve the parenting agreement that the parents had negotiated amongst themselves, and that although her own son was fully supportive of the mother having sole custody of the daughter without her expressed consent, which she refused to give for quite some time, the litigation could not be resolved. The grandmother continued to maintain during her testimony that the 2015 parenting order had been imposed by the court, whereas the court order on its face makes it clear that ultimately she signed off on the parents' proposed agreement and the order was made on consent. So a consent order means that the parties have agreed that the order should be imposed, and usually the court will go along with that so long as it's not crazy town or illegal or something along those lines. So it wasn't that the court forced this, it was that they agreed to this. They came to a negotiated agreement, and this was the plan. Unfortunately, the grandmother's understanding of the events that transpired between the parents appears to be based solely on the father's own version of the facts that he reported to her. I find that it is important for the father to have his mother's approval, and I find as a fact that frequently the father reported to his mother what he knew she wanted to hear, and not necessarily the complete story. So she's getting filtered information through him, and he's presenting himself as the good kid. He's her good son, and he's doing his best here, and not necessarily. So she's got faulty information from the outset. Clearly, the grandmother was unaware of the father's attempts to reconcile with the mother in the early years after their separation. She was also unaware of all the times that the father failed to call the daughter or failed to call at the court-ordered time, which is why many of his phone calls were missed, or failed to show up when expected, and she had no knowledge of the nature and content of the parties' countless exchanges, in person and in writing, where the mother's stance on various matters related to the daughter's well-being were conveyed to the father, and during which she attempted to communicate the daughter's needs to the father. The grandmother's view of the events that transpired between the parties was therefore distorted, as she often was not privy to all of the relevant information. And that's kind of sad here, right? Because there's a little girl involved in this. And you think maybe if the grandmother had had this full understanding of what was going on, if she knew that the mother was genuinely caring about this kid, that maybe she would have taken a different position. It might be that this is a needlessly acrimonious situation, partially because of that. So family law is also full of tragedies. It's tough. I really, I don't do family law. The closest I have come to doing family law is some stuff on emergency protection orders, which are sort of pseudo-criminal, if I could say. However, I got huge respect for everybody practicing in that sphere because it is really tough. It is a really difficult thing. They have to be both excellent lawyers in a very difficult field. They have to deal with a lot of tension, a lot of drama, and they also often are sort of having to play kind of partial therapist just to try to to manage the emotions and the difficulties involved there. So it's a tough job. But let's get to the absolute showstopper moment here. This is the moment in court that just, you can't believe that this kind of thing can happen. So this is one of those moments where the lawyer, I'm sure, was just, one lawyer was probably, sort of, well, I can't say gleeful just because this is such a weird scenario, but the mother's lawyer was probably just in agony here. Let's have a look. This is a little crazy. So the mother, a significant incident occurred during the trial that completely shattered the mother's credibility and made it clear that she was prepared to lie, cheat, and deceive whenever needed to achieve her means. So let's just stop here. I mean, one incident blows her credibility out of the water, just completely annihilates her. And do you not think, like, from what you've seen of the assessment of the father's credibility and the grandmother's credibility, that if the mother could have just held her own, that maybe, she'd be doing really well in this? Yep. So let's see what happened here. 1 week prior to the commencement of the trial, and after having reviewed the lengthy text message exchanges uploaded by the father as part of his evidence for the trial, the mother served and uploaded her own version of some of those text messages. Some of the text messages uploaded by the mother were very damaging to the father's case. They included statements purportedly made by the father to the mother to the effect that he recognized that she was a better parent, that he was unable to care for the daughter the way the mother did, that he did not want to have the daughter in his care primarily or even for half of the time, and that it was his mother who was driving this case, not him. So all of that is the sort of stuff that would be incredibly damaging. But you see here that there's two versions of this. And that's already a hell of an allegation, because once you have that, it means somebody has tendered false evidence to the court. That is basically a bomb that's going to go off in somebody's face. And before you do something like that, you need to be real sure it's going to be going off on the other side of the field. Because if it's going off on your side of no man's land, that's going to be a rough day. And as a lawyer, you do your absolute best not to tender any evidence that you don't think is accurate. But you are reliant often on your clients. You do your best to spot any sort of, forgery or fraud or anything like that, because you have a duty to the court. If my client says, here's a document and I know it's a forgery, I cannot present it to the court as genuine. You just can't do it. So, I'm not faulting the lawyers here. I am sure that they put in the effort to make sure that what they were tendering, that they thought it was real. And, the lawyers also get very filtered information. They don't necessarily, they don't hear from the other side in the same way. So let's see where this bomb goes off here. You may already have an idea. So in his testimony, the father vehemently denied that he ever sent those text messages to the mother. He alleged that they had been fabricated by the mother and maintained that position throughout. In her evidence in chief, the mother strongly objected to the father's allegation that she had fabricated those messages. She explained how the father's version of the messages had been downloaded on a computer and printed out using a word processing software, which made it easy for him to remove the damning messages from his string of messages. She testified that her own copies of the text messages were screenshots, pictures, that she had made from her cell phone directly and then emailed to her lawyer. As such, she stated she had no ability to fabricate a different version of these messages. Therefore, the authenticity of the mother's text messages became a key issue in this trial. And you can see why the mother's lawyer would have accepted that, right? That's something where you say, hey, listen, I think that my screenshots are better than your Word document. I certainly can see myself coming to that same conclusion. I can see most lawyers coming to that same conclusion. I think it's a very reasonable assumption here. So on the last day of her cross-examination, the mother was questioned about those text messages. Although this trial proceeded virtually, because of course COVID has a lot of trials happening, online rather than in person. So this would have gone down very differently in person. This is a distinction between in-person trials and virtual trials and, online trials, which kind of illustrates some of the problems that online trials may be facing. So counsel for the father asked her to retrieve her phone and to show him the damning messages directly from her phone. So counsel for the father is playing a real, it's a dangerous game here. I mean, he's putting all of his chips in, because if she can do that, that's going to be really deadly to the father. But if she can't, it's going to be really deadly to the mother. This is basically saying, let's see where that hand grenade actually is right now. Let's do this. So at first, the mother stated that she did not keep messages on her phone for this long, that she had recently deleted a bunch of them, and that it was likely that they were no longer on her phone. It's that moment here. This is one of those moments where I'm just picturing this as, as a lawyer, and you can just imagine how this looks in court, right? You can just see how this would be going down. I just deleted them. That moment where they start to wriggle on the hook, and you've pinned them down to something terrible. You've got them pinned down in a nasty lie. And this is going to be the moment where the lawyer is moving in for the kill. So, when forced to admit that she'd sent the screenshots of the messages to her own lawyer only a few weeks before, the mother still maintained that they were likely no longer on her phone. When asked to show her cell phone to the camera and scroll down slowly so we could see how far the text message exchanges between her and the father went, it became obvious that the mother was keeping her finger on the screen of her phone to make sure it could not scroll down or past a certain date. Oh, can you imagine, this moment here? This one is for the mother's lawyer, because that had to have been a rough moment there. All right, so carrying on here. It took a lot of direction, including eventually by myself. So the justice here is having to wade in personally and saying, you got to stop doing this, for the mother to finally remove her finger from the screen and to stop interfering with her phone to allow everyone to see the string of messages. It became clear that she did, in fact, still have all of her text messages going back years. So she's already been lying in court and trying to hide evidence from the court. This is already really bad. Really bad. The mother then became very defensive and agitated, as people often do when they're caught in this kind of moment. She started to question the purpose for which she was required to do this, became belligerent with opposing counsel, and quite flustered by the process. Often when people are caught in a lie, they get angry and they start trying to turn things on the lawyer. And, as a lawyer, sometimes you can have somebody who's being very hostile, very threatening, but that's the moment where you've got them. So you keep going. So when directed to go to a specific date in July 2020, the date at which one of the very damaging messages had purportedly been sent to her by the father, she started to give all sorts of explanations as to why it might not be there anymore, while searching for the particular date on her phone, including that she also had exchanged many text messages with the father using her iPad, which conveniently was now in the possession of her parents in Nova Scotia. Very convenient. Needless to say, the damning messages could not be found on the mother's phone. Before the father's counsel could go to the next messages, the mother requested that we proceed immediately to the lunch break, as her young baby was becoming fussy and needed to be fed. Counsel for the father strongly objected to taking an early lunch break before he was through with his questions regarding the mother's phone, and alternatively requested to be permitted to send one of his employees to retrieve the mother's phone to have it in his possession to continue his cross-examination. So there's two reasons why he's going to be really upset about this. One, when you've got somebody on the hook, when you've got that momentum in your cross-examination, when you are getting to what you need, you don't want to give the witness a break to sit and think about things and to say, hey, and to think about how to get out of it. You want them to be reacting live in that moment to, where they're flustered, where they're, because somebody who's being honest can typically or is going to be much better able to respond to questions. But it can be hard, when you're talking about somebody who's lying, and once they've been taken out of the story that they plan to tell, once they realize that that's no longer going to work and they're having to do it on the fly, it's way harder for that witness to keep lying. So if you instead give them another break and let them think about it, now they can come up with a new story, and you have to tear apart this new story all over again. It can be like starting over anew from cross-examination, as if you were just beginning over again. So sometimes, for instance, it might be 11 o'clock and the Crown is about to call or is finished with a witness and is about to turn that witness over to me for cross-examination. I know I want to spend a couple hours on that. I might say, hey, can we have our lunch first and then we'll do our cross-examination? Because I don't want to give them that break in the middle. The other thing, of course, is this phone is now a critical piece of evidence. And I'm sure that the counsel for the father is now thinking this thing's going to end up in a toilet. It's going to get dropped. We got to get this phone because it is critical. So he does not want this to happen and is doing his best. So I agreed with counsel's request and gave the mother very strict instructions that during the lunch break, her computer needed to remain turned on and its camera pointed at her cell phone, which was to be left untouched on a table where it could be seen at all times until picked up by the father's counsel staff person. This was to ensure no one would have an opportunity to alter its contents until it was picked up by the staff member. The father's counsel, or one of his staff members, remained on the Zoom call throughout the lunch break to make sure no one touched the phone until we returned. So I mentioned that this is a bit of a thing from, COVID situation. If this was not a COVID times kind of trial that's happening remotely, they would have just said, hey, give your phone to the sheriff. Sheriff's going to hang on to it, or the clerk's going to hang on to it. You're not going to have it during this lunch break. But here they're coming up with a novel solution. Keep it on camera the whole time. Make sure we can see it 100% of the time so that we know you're not futzing around with this phone. When I returned from the lunch break, I was informed by the father's counsel, this was acknowledged by the mother's counsel, who was also present on the Zoom call during that time, that the mother had remained at her computer throughout the lunch break with her baby on her lap, although she had claimed that she needed an early lunch break to feed her baby. So why not feeding the baby? That seems like a problem. Shortly before the father's counsel staff person arrived at her home to pick up the phone, the mother was disconnected from the Zoom call for a period of 4.5 to 5 minutes. During that time, counsel could not see the phone. So you might be wondering, why would the mother's counsel be acknowledging this? Well, mother's counsel has a duty to the court. Mother's counsel, she's got a duty to her client, but she also has a duty to the court. She can't, say, oh no, that never happened if it clearly did. So mother's counsel is behaving ethically here. I got no beef with mother's counsel. It sounds like she was kind of tanked by this, or he or she. So I haven't actually looked up who's the lawyer's names on this one, so I'm not actually sure. All right. Unsurprisingly, when the phone arrived at the father's counsel's office, all text messages between the parties that the phone ever contained had been entirely wiped out. Isn't that just, this is a movie moment here. This is one of those things that, normally trials are kind of boring. Stuff just, kind of happens the way it should be. A witness might break down or be caught in a lie, but there usually isn't this kind of stuff going on. This is unusual. And I realize this may be unusual to a lawyer. Nobody's getting stabbed here. Nobody's getting shot, nothing like that. But this live destruction of evidence and is something that I've never seen before. When presented with those facts, the mother vehemently denied that she was disconnected from the call for that long, insisting that her computer had just crashed and that she had restarted it and reconnected approximately 30 seconds after it crashed. When asked again, both counsel confirmed that the mother had been disconnected from the Zoom call for almost 5 minutes. And I'm sure that the counsel for the father probably busted out their stopwatch because that's a critical moment there. Once again, the mother tried to offer several reasons why the messages might have been erased before becoming once again very agitated, argumentative, and defensive. Interestingly, this was the only time throughout this 2-week trial that the mother's computer crashed. Yeah. Yeah. That's just rough. From the above, I come to the following factual findings. The mother's version of the text messages exchanged between her and the father is not authentic. Those messages were fabricated by the mother or someone else at her behest. The mother lied to the court when counsel was trying to get her to access the text messages on her phone. She deliberately tried to conceal the history of the messages, and when she failed, she lied by saying she could not access them before. During the lunch break, the mother intentionally disconnected from the Zoom call just long enough for her to delete all the text exchanges between her and the father that her cell phone contained. I find that she, or someone else for her, erased all of those messages in clear breach of my specific order. Which doesn't sound like much, but when a justice of the court is saying, that this is a clear breach of their specific order, it means they're pissed. It means they're, seriously angry. Sadly enough, this is not the only reason why the mother's testimony can be given very little weight. The evidence before me, or lack thereof, raises significant concerns about the veracity of many allegations made by the mother during the course of this litigation. For instance, while the mother asserts that she suffered from cancer back in the fall of 2019 or 2020, she failed to produce any medical evidence whatsoever supporting her allegation in that regard, despite a court order requiring her to do so. And it wouldn't have been that hard, right? I mean, there's all sorts of things that you could produce to support that, like your medical records. While the mother asserted that she failed to appear at the settlement conference before Shelston J on January 14th, 2020, because she and the children were ill, they allegedly contracted COVID, the mother failed to adduce any medical evidence supporting same, despite being ordered to do so by the justice. While the mother alleged that the daughter suffered a severe concussion back in January 2020 while in the care of the father, much evidence was adduced by all witnesses in relation to this incident, which according to the mother required the daughter to travel to Toronto to be seen by a specialist there. The mother completely failed to produce any medical evidence whatsoever supporting those claims, despite a court order requiring her to do so. And you'd think that this would be one of those things, like this is bombshell evidence, right? If you're saying that the father is being negligent and as a result she suffers a severe concussion, you'd want to bring your A game in terms of backing that up. I'd want to have as much stuff as possible so that you can really just grind that in, right? This is the kind of thing that you really want to make big noise about. So, where's the documentation? I find as a fact that the mother lied to the father, to this court, and to others about the daughter having broken her wrist during the father's parenting time just a few weeks before the trial began in an attempt to bolster her position in the trial. I find that she continuously represented to this court the daughter had broken her wrist when she knew full well that this was not the case, as confirmed to her by her doctor on or about April 28, 2021. When it was confirmed that the daughter's wrist was not broken, the mother took swift steps to remove the father's access to the daughter's MyChart, her online medical chart, to ensure he did not have access to that information. That's ugly. I mean, making up injuries to the kid, and blaming it on the other side, and then trying to ensure that he can't defend himself against that allegation. Family law is mean. It's nasty. It makes me sad. I'll go as far as that. Well, there's a reason why I avoid it. I think that I might not be as my cheerful self if I was practicing in the area of family law. Conclusion. Faced with a complete lack of credible evidence from the oral testimony provided by the three main witnesses in this matter, I had to rely principally on the documentary evidence adduced in the context of this trial, excluding those communications between the parties that I concluded were not authentic. So he's relying on documents, except the ones that are clearly BS. That documentary record included voluminous emails and text messages exchanged between the parties, which were quite revealing as to the events that actually took place between them over the years. That documentary record also included third-party records from the Children's Aid Society, the police, the daughters' schools, council's communications, and some health records. So basically, the justice can't believe any of these people and is having to do the work to figure out what's going on solely from the documents. And it sounds like there were a lot of documents, so at least there's that. So ultimately, we have a situation here where it looks like the mother was trying really hard, and probably, you know, the difficult thing here, especially when we're talking about family law, is that as much as you might be talking about people doing bad things, they're probably not bad people. And sometimes people do bad things because they really care about their kid, and they're really worried that the court is going to do the wrong thing and give their kid to the bad person who may or may not actually be a bad person. It's really stressful. It's really difficult. And, but this bit here of, tampering with the evidence is utterly destructive to credibility. It is just, the court at that point simply can't rely on anything that you said when you're willing to go to that extent to, to present false evidence to the court. It's absolutely destructive. I mean, no lawyer would ever tell you to do that. No lawyer would condone you doing that. If a lawyer knew that that was your plan, they would, they'd tell you you're on your own, that they're not going to be there, helping you out in that course. So again, I want to be real clear here. I don't think that the lawyers were in any way involved in this. Family law is a very difficult thing. Weird stuff comes up. But this, this has got to have been just an absolute shocking moment. And, I realize that I'm saying this in the context of I'm a lawyer, so, legal maneuvering to me is what's, shocking, as opposed to necessarily, other stuff. But a lot of the other stuff doesn't show up on transcripts. I suspect I'm going to get comments with people going, tell us about that shooting thing, notwithstanding the fact that I wasn't there. I didn't see much. I mostly know about it, the same stuff everyone else knows because it was on the news. But I suspect that's what the comments are going to be about here. But I mean, this is wild. This is like a movie or a Matlock moment where you just, you catch the witness doing something just so egregious in terms of the court process. So I wanted to share this one as just an example of, how far off the rails the court process can get when people are, willing to cut corners maybe. And yeah, this is one of those cases that lawyers share with other lawyers to go, can you believe this went down? And, it's hard to believe. I really sympathize for everyone involved. I mean, for the lawyers, it's going to be difficult just because this was a rough day in court. For the people involved, it's going to be even more so because there's a lot of tension here. I didn't get to the ultimate, rulings here because there's a lot going on in this particular file. It's a tragic scenario. Lots of family law files are. And perhaps at some point I can discuss one of the reasons I mentioned that I blacked out the names. And one of the reasons I did that is actually when I was a kid, there were family law disputes, and at least one of those decisions is a reported decision. So it shows up, and maybe at some point, I'm probably not going to do it for a while. Maybe at some point I'll talk about that decision and talk about how it sort of jives with my experience, but not today, and not not soon, I guess. I'll think about that one. Anyway, thank you for watching. I wanted to share this one with you. It's a wild case, and it's not the kind of law I do, but it really, I think, shows why it's not the kind of law I do, because, I mean, family lawyers are tough. Hats off to them. Seriously, it's a rough field. I mean, I just represent, people accused of, attempted murders and things like that. I mean, that's way easier, believe it or not. Maybe I'll do a video at some point explaining why that's easier. There's a whole lot involved in that. Anyway, thank you for watching. I hope that you found this to be interesting. Hope you found it to be educational. I hope if you're ever a witness that you've learned something from this, because all of these people would have done much better if they had approached the court in a different way, in a way that was, where their evidence was better evidence. The mother here, had she not tried to improve her situation, which appears to be the case here, I think she would have been doing way better in terms of this court proceeding. But I can't say for certain. I didn't watch the trial. I'm just relying on the justice's findings as facts. I can't say for sure one way or the other, but that's ultimately what the court was finding. Anyway, thank you once again. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Jason Elliott, Canada's National Firearms Association, Slightly Left of Center Good-Natured Hypothetical Firearm Association, Mike, Kyle Martin, Jean-Guy Toussaint, CCFR, and the Canadian Shooting Sports Association. And at the $30 level, Sights and Arms Limited and Marc-Olivier Demour. And at $20, Raymond L. McKinnon, Matt Ward, Mark Whittington, Jane Babe and Luxor, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Del Salt. Thank you as well to the $10 supporters who will be in the crawl immediately following, to all of my supporters, and to everyone else watching. Please, as I said, like this video, share it with your friends, subscribe if you haven't already, and thank you for watching. I hope this has armed you with knowledge. And I hope you never end up in family court. It's a rough place to be. Cheers.